Senator Kerr, Senator Neal, Senator Schickel, Senator Schroeder, President Stivers, Senator Turner, Senator West, Senator Wheeler, Senator Carroll, Chairman Westerfield.
Here. Seeing that we have a quorum, we're authorized to do business. We're going to jump right in. We're going to get as far as we can go. I've got you all for an hour and a half before we lose folks to other committees, and we might use all of that time. So without further ado, Senator Storm, come on up on Senate Bill 31. There are some folks that want to speak, and I'm going to let some folks speak that did not speak the last time. But we're not going to spend a lot of time on this bill because we've spent a lot of time on this bill already. So with that said, Senator, if you have any opening remarks, I believe the FOP, someone from the FOP has signed up. Thank you. I appreciate you all sending me a text and letting me know. I don't have that sign-up sheet. Do we? No, they'll get it, John. Thank you. I appreciate it. All right. You have the floor, Senator.
Thank you, Mr. Chairman, committee members. Thank you for allowing me to come back again today and discuss with you Senate Bill 31, which would put in place a speedy trial clock for Kentucky. Since the last time we were here, there's been a lot of effort, a lot of additional conversations with interested parties and stakeholders, which has resulted in additional changes to the bill, and I would direct the members to PSS 3, which is the Senate committee substitute, and I would like to discuss those changes if the committee would be willing to consider a motion to adopt that.
Got a motion from Senator Wheeler and a second from Senator Schickel. All those in favor of adopting the sub, please vote by saying aye. Aye. Those opposed? Sub is before us, Senator.
Thank you, Mr. Chairman. So very quickly, the first change is on page 7, line 12 through 13. This was a drafting or typographical error that was noticed by AOC. It was pointed out that a person's history of drug or alcohol abuse should be a prerequisite to the alcohol or drug testing, and that was inadvertently deleted from page 6, line 6. And we're basically adding this back in. It's not a new provision. It's just reinserting an existing provision that was somehow left out between the changes. The second change is new language was added on page 3, lines 9 and 10, and again on page 9, lines 22 through 23. This was brought to my attention by DPA, who wanted the time frame extended regarding the 180-day or 90-day hearing. So we previously had 48 hours in there, and what we've done is try to give flexibility to the judges and prosecutors. So we now have 14 days prior to the exhaustion of the speedy trial clock up to 7 days after, so 21-day time period there to give those judges and prosecutors a chance to have those hearings. The third change is new language is added to create subsection 10B on page 3, as well as subsection 8B on page 10. This was brought about by conversations with victims advocate groups, and their intent was that if the judges had already had a clear and convincing finding that someone had a public safety risk, that there would not need to be a second hearing. We have discussed with the victims advocates, and we're going to try to make some technical changes to the language, perhaps with a floor amendment that I've agreed to work with them to facilitate. The fourth change is new language is added on page 4, lines 1 and 2, and again on page 10, lines 14 and 15. This was, again, another provision that was brought to me by the victims advocates. It allows compliance with Marcy's Law. It also allows victims to have notice of the 180-day and 90-day hearings that are discussed in the bill. And a couple key points to keep in mind. This bill only deals with those individuals that are unconvicted and afforded the presumption of innocence. This bill does include a 180-day clock for felonies, 90-day clocks for misdemeanors for those individuals who are in custody. If they're out on bond or have conditions of release, they would not be applicable to those individuals. We've also made concessions regarding the Kentucky State Police Crime Lab, and KCPC evaluations. This sometimes cause significant delays, so we've already incorporated those in there. Defendants can also waive the right to a speedy trial if they're consulting with their lawyer. They believe that's in their best interest. And then lastly, the parties can go before the court and say, Judge, we have good cause here that exists. Perhaps it's a natural disaster. Perhaps it's an ailment that has befallen a litigant. And, maybe there's complex discovery issues out there. So, again, good cause would also be available to those parties. So this is a conservative legislation. It's based on constitutional principles in the Sixth Amendment of the United States Constitution, as well as Section 11 of the Kentucky Constitution. And I would ask the members to vote yes for this. I do have some guests with me today, and I would defer to them at this time.
Good morning, Chairman Westerfield, members of the committee. Thank you all for having us here again to continue this conversation. My name is Shelley Hampton. I'm the Director of Government Affairs for the Kentucky Association of Counties. You previously heard our testimony, our concern with our continued and increasing jail costs. The state pays for felons once they are convicted of the felony, but pretrial, that all falls to the county to take care of all of those costs. I will forego any further comments in favor of Whitley County Judge Pat White, who is on with us virtually, and I would like to give him some time to make some comments. Judge White,
go ahead. Good morning. Good to see you.
Thank you all for having me, and thank you for the opportunity to contribute to this. I appreciate the Senate committee hearing from me and hearing from the concerns of counties, and I appreciate Senator Storm bringing this bill up to try to help relieve some of the pressure that counties faced over the past few years. I'm sorry that I couldn't be there in person. We've had some issues with COVID in the family over the last few days. I just got released from COVID quarantine yesterday. My wife just tested off today. She had tested positive over the weekend, and so I've had to reschedule fiscal court meetings and move some things around. I apologize for not being in attendance there today. But the jail cost issue for most counties, including Whitley County, is the issue, the primary issue for our financial concerns. Just to give you some perspective, this year alone, Whitley County, which is a small county of around 36,000 people, will spend around $1.7 million in contributing to jail costs. And over my tenure, this is my 16th year, we will have lost near $20 million that we've contributed to losses in operation of our jail because of these pretrial expenses. These costs are not generated because of any county action. They're not generated because of anything the county controls. And I think that's of great concern for us because this is such a huge proportion of our budget, ranging between 30 to 40% of our general fund budget goes to this one single expense. And we have no ability to adjust the policies as it affects those things. All the crimes that people are in jail for are state-related crimes. That's what they're arrested for, and that's what they're detained for. The state oversees a lot of the arrests through the state police. 70% of the arrests for these crimes come from state or city officers. Only about 25-30% come from county officers. Once they're in jail, they go before state judges and state prosecutors. They're bonding agents that set how long or how much of a bond they have to be able to get out of jail are employed by the state. The entire process is dominated by the state, but the county receives the bill for that. In many counties, it's just becoming so burdensome that we just can't hardly remain solvent with it. And those costs went up substantially through COVID. There was some movement to release Class D felons, and so we lost a lot of that income in Whitley County. That created an additional expense of around $400,000 a year to us. So we went from a $1.3 million a year loss to a $1.7 million a year loss. Now we've been able to sustain and make it through those expenses okay, as long as we've had these federal transfer payments coming and all these COVID-related monies coming. But in normal operations, this really drags down what we're able to pay our employees. It drags down the equipment we're able to provide for them. It keeps us from being able to maintain our facilities, and it really explains why county employees are so underpaid and why the county doesn't have the resources to do a lot of things that even cities and even cities and other parts of state government are able to do. So I just appreciate you all considering the needs of counties and how dramatic this effect is on us. And I appreciate you all taking the time let me speak a little bit this morning. And thank you, and I'll address any questions if there are any.
Thank you, Judge. Again, good to hear from you. Glad you're doing better. Glad your wife's doing better. Anything further before I hear from some of the opponents here, Senator?
Not at this time. Thank you,
All right,
Mr.
I'm
Chairman.
gonna let you have the final word when we get to it, but I'm gonna have Sean Helbig come on up with the FOP, or whomever on behalf of the FOP was gonna speak to come on up, and then Judge Ward, you're on deck. I don't see you, but you've signed up, so there you are. Judge, I know Judge Summey's signed up too, but she's had a chance to address the committee once before, so I'm going to start with Judge Ward. Won't get to Judge Summey this time unless we've got time. All right, gentlemen, if you can, keep your remarks to 5 or so minutes.
Absolutely,
Go
sir.
ahead. Thank you.
Thank you. My name's Sean Helbig. I'm the National Trustee for the Kentucky Fraternal Order of Police. I've been in law enforcement for 23 years. Most of my time was spent with the Bowling Green Police Department and working for the Warren County Attorney's Office as a detective.
Ryan Straw, Vice President of the Kentucky State FOP and Governmental Affairs Director.
Kyle Burton, member of the Legislative Committee for the Kentucky State FOP.
So today we're here in opposition of 31, SB 31. I'll simply ask the question, why are we here? Why are you here? Why was I the police for 23 years? The answer should be the same. The answer should be that we're here to protect our communities and provide safety and security for our communities. And we do know that there's evil in the world, and there are people that do bad things. This bill does not make our communities safer. It does not provide for the safety and security of our community. In the last 24 hours, I've seen 2 reports come up on my news feed. Last night in Louisville Metro, 4 individuals stole a car, ran, shot at the police, ended up wrecking the car, and have been taken into custody. I don't know those 4 people. I don't know if they're repeat offenders or they're out on bail, but studies have shown us that most of the people we arrest for violent crimes or that commit violent crimes are often regulars in our justice system. Just yesterday as well, in Indianapolis Metro, there was an individual that was out on bail on an ankle monitor that took a gun, carjacked an individual with a handgun, and fled the scene and was later taken into custody. Granted, those are just 2 cases, but I can find case after case after case where we've had people that have been out on bail or been out on early release that have caused additional harm to our communities. The social experiment of bail reform has failed miserably across our country. You know this because crime is skyrocketing across our country, especially in our metropolitan areas. I'm not here to say that all or every person that commits a crime is a repeat offender or is out on bail, because there's never an all or an every in any situation. We are finding that the majority of our violent crimes are being committed by repeat offenders that are out on bail or out on early release. In 2017-2018, the University of Utah did a study of Chicago shortly after they introduced bail reform and made it much harder for judges to keep people in on pretrial confinement where probable cause had already been established. 41.3% of people out on bail committed new felonies while out on bail. The date was 2017-2018. Let's look at the last 2 years where a lot of people in our country have made it acceptable to break the law and not be held accountable. Just look at the last 2 years of what's happened in our country. We have to hold criminals accountable. As the FOP, we average about 2 officers a day across our country that are being shot. We've had 6 officers killed in the first 47 days of this year by suspects, not all of which were out on bail or on early release, but the majority of those officers were shot or killed by people that are regulars to our justice system and have been released because of programs like bail reform. Frankly, ladies and gentlemen, I am tired of going to police funerals, and I go to a lot of them, and I honor every one of them. But we have to protect our citizens. We have to hold criminals accountable. This bill drastically raises the standard to be met before a judge can protect the community that they were elected to protect. I simply ask this question: before we change a standard, can you folks show me that a majority of judges are not applying the current standard appropriately? The current standard is safety of the community and risk of flight. This new standard is drastically higher than that standard. And I believe that we've seen our judges apply that standard properly. Could we account for COVID? Of course not. I hate that people are in jail longer because of COVID. I didn't create COVID. None of us created COVID. I will end with this. Most all of us in this room know who Mike O'Connell is. He's the county attorney for Jefferson County. I think all of us in this room could argue that he is probably one of the more liberal county attorneys in Kentucky. His statement yesterday, criteria for release should not be the ability of a certain person that has money or doesn't. It should be the threat of the community and whether they have a history of flight. A liberal county attorney just quoted what the current standard is and says that should be our current standard and that should be the standard. I ask that you reconsider this bill in regards especially to raising the standard that a judge has to meet before holding a potential violent criminal in custody until trial. Thank you so much for allowing us to testify today, and I will stand for any questions if you have any questions of us.
Thank you, gentlemen. I appreciate it. I'm going to ask Judge Ward to come on up now and speak. Again, Judge, about 5 minutes if you can. I hate it when judges give me time limitations. I sincerely do, and so I don't do it with any kind of joy, but I don't have the full day to have my docket. I've got 90 minutes, and I've got 4 other cases on this docket, I'm afraid.
Listen, I understand about case management, sir. So thank you so much. I appreciate the time you're giving us.
Glad to have you both.
Thank you. So, Senators, I really do appreciate your time. I'm one of your circuit judges in Campbell County, and it really just is a blessing every single solitary day to serve my community as a judge, and I'm very thankful. So I want to let you know that I'm not here because I'm worried about my schedule. I'm not worried about how hard I have to work. I'm not worried about how this bill is going to impact my daily life, although I will tell you that it is going to create a lot of havoc with my schedule and a lot of havoc with my work. But that's not really what my concern is. I sort of echo what the state police have to say, is that this really is about safety of the community. This bill really isn't about a fast and speedy trial. What it comes down to is about bail reform. If you really look at the bill is only designed, number one, to protect people who are in custody. The Constitution provides a fast and speedy trial to every single solitary defendant, whether you're in custody or whether you're out of custody. So if you really look at the bill, what it's trying to accomplish is that basically I can continue a case forever if I have good cause. There's no time limit on how long it takes me to try a case. But if I try a case and I can't get it done in 180 days, I got to release a defendant from jail. So a defendant can be an obstructionist. He can delay, but he gets released from jail. So really this is all about bail reform. And the concern that I have is when a judge looks at bail from the very beginning, what we are looking at is whether a defendant is a flight risk or whether we believe that they're a harm to the community. And if we believe that, we set bail commensurate with that risk. This bill basically will say that although I've already made that determination, I've already had a hearing, I've already had an opportunity to speak to victims, I've already had an opportunity to hear from prosecution and from the defense, that now it doesn't matter what I've decided. 180 days have ticked by, maybe even at the fault of the defendant, and unless I can show that the defendant is a imminent, serious risk of physical harm to someone, and a particularized risk, then I have to let him go. And sirs, what you're going to do is you're going to end up releasing a lot of individuals that you do not intend to release. If someone burglarizes your home, he probably gets out. If someone's possessing child porn, he probably gets out. If a person's taking pictures of children naked and uploading them on the internet, he probably gets out. If you have a drug trafficker, he probably gets out. And you may think that that's not true, but if you look at the standard that you want me to have, which is clear and convincing, of a particularized risk of imminent serious physical harm, what I'm saying is true. You are going to allow dangerous people out on the streets after your judge has already made a determination that if this person does get out, that he probably will create a flight risk or a risk of harm. It doesn't matter anymore that the defendant is still a flight risk. I have to release him. And so honestly, I do not think this is a constitutionally conservative bill. You can label whatever you want, but it's not. We had Vera Institute meet us back in September. And basically the Vera Institute, if you're not familiar with that, I would strongly encourage each and every one of you to become familiar with who they are. But they basically told us that this was their bill, going to be sponsored by Senator Storm. And when we met with them, we basically told them, here's the problem that we have. It's not about how fast a judge can work, and it's not about needing more judges. What it really is about is we've got some problems. You want to pass a bill that only addresses symptoms and not really corrects the problems. The problems that we have is it takes us months to get labs back just for a simple test on whether something is a controlled substance or not. It takes us over a year to get DNA results back. It's taking 11 months to have someone evaluated for competency. I have a judge who called me last night very upset. He has a district in which he is the family court judge and a general jurisdiction judge. He has slotted 4 DPAs, meaning he's entitled to have 4 DPAs in his county. He has 1 DPA. They cannot fill the other 3 spots. So he has said to me, how about we fix some problems? How about we talk about if the DPA's office is not able to fill those spots, how about we be able to contract with attorneys, private attorneys, and allow those private attorneys to try those cases? How about we privatize the state labs? How about we allow mental health professionals who are in our communities do evaluations for competency? How about we try to start really fixing some of these problems? And then at the end of it, what I think you might see is you might see some of the concerns that people have about money versus safety. I think you might see we might be able to address some of these problems. So that's all I have to say. I thank you so much for your time. Happy to answer any questions.
Thank you. I don't think, and Judge Summey, I appreciate you coming, but I'm gonna move along here. I don't think I see anybody else on this sign-up sheet or on, I don't think there's anybody else. Senator Storm, you want to have the final say here?
Questions?
I'll give you a minute or two, please.
Thank you, Mr. Chairman, committee members. Just to address a few of those issues, again, we're working on Committee Substitute 3, and I also discussed the change that's reflected there in paragraph 10B, which is on page 3. And we've already talked about that in the event the court has made a finding of public safety risk by clear and convincing evidence at a due process hearing at any stage of the proceedings, then we've already put in here that the defendant's not entitled to automatically be released. So that concern has already been addressed. We've already addressed the KSP lab that the judge mentioned, and we also addressed the KCPC evaluations. I can't control, nor can the litigants control, nor can the judge control the Kentucky State Police Crime Lab. We all know that that's an issue, and we've tried to address that in this bill. Again, defendants can waive these rights, but I don't think that there's anything taking away the judge's discretion to make an assessment on public safety.
Let me ask you a question, Senator.
Sure.
Can a judge still keep someone in custody?
Yes, absolutely.
Thank you. Can a judge continue this beyond 180 days for various reasons under the bill?
Yes.
Thank you. Are we requiring that judges make a finding on the record for why they're keeping someone in?
Yes, 2 things. Already in existing language on page 10 in the statute that we're not changing, if a court determines that a defendant shall not be released pursuant to subsection 6 of this section, the court shall document the reasons for denying the release in a written order. That's already the law in Kentucky. What we're asking the court to do is make individualized findings regarding these issues.
Thank you. Senator Stivers, you had a question?
Yeah, I have a question of whoever wants to answer it. I appreciate, because yesterday Senator Schickel, Senator from Boone, and I had pretty extensive conversation with Sean, Ryan, the 2 judges. They gave me some ideas and made some suggestions, And I saw Judge Ward just make the comment that this is, not a conservative. What I'm interested in is what's fair, not liberal or conservative. And you alluded to, and there were several things in the conversations that were alluded to. Right now, one, the bail forms and what pretrial does and what judges consider is primarily rules of the courts, if I'm not badly mistaken, and somebody can respond to that. So anything that Ryan or Sean would have questions about would be related to court procedures, not really legislation. Second, the standard on review on a speedy trial act, the scrutiny, and somebody can correct me if I'm wrong. I actually had to go get my law books out. I'm one of the old guys. I don't use computers. The scrutiny on someone who is in custody versus not in custody on a speedy trial motion is totally different, if I'm not badly mistaken, because you're looking at what freedoms are being restrained. And if one wants to make a speedy trial motion, you consider the totality of the circumstances, which includes, are parties ready? Can you get witnesses here? Are there extraordinary circumstances? Those types of things are taken into consideration on speedy trial, which also, are you in custody? I believe that's one of the things that's considered. And then one comment was made to me in this, that individuals were released even though they had bail jumped and had cut their home incarceration monitors. Those seem to be indicators they would be flight risks, which would, in any criminal situation, whether it be a misdemeanor or generally you don't see it in a capital offense, would be detrimental to one being released on bond if they had committed acts of flight, because risk of flight is to be considered highly on the risk level for return. So all that comes back to this, and looking at the system. Am I wrong about how, Judge Summey, anybody, Judge Ward, about how this plays out, about how the system is currently set up? And
Back up, Judge.
So, Senator Stivers, you're correct on a lot of things that you're saying. But the difference is that the 180-day mark changes that standard. So when we look at the flight risk and everything that we do now, we're looking at whether the defendant is a risk of flight or a danger to the community at the very beginning. So this bill right now, it basically says at the very beginning, I can go off of that standard, number one, and show by clear and convincing evidence that a defendant is a particularized risk of serious physical injury. So I can make that determination and bypass the original determination that I make. But the original determination I make is whether a defendant is a risk of flight or a danger to the community. At 180 days, this bill changes that standard. I no longer can consider the defendant's flight risk or whether he's a danger to the community. I now must only consider whether the defendant is a particularized risk of imminent serious physical harm to someone. So the standard gets changed at the 180 days. And at the 180-day mark, again, yes, I can continue the trial. But the way that the bill is currently written, and I've asked many, many judges for their interpretation, and that's what we do, right? You do the law, we do the interpretation. We are not saying that any of the things that are in the bill exempts that 180-day bond hearing. So if that's what Senator Storm means to do, then I would like to have at least a legislative intent on that. But Senator Stivers, the other thing that you were saying in terms of the rules that we adopt by AOC, yes, the Supreme Court has set out a lot of standards for us, and there's things that we have to look at. We have to look at the defendant's criminal history. When we're looking at flight risk and we're looking at danger to the community, we're looking at the defendant's criminal history. We're looking at their past FTAs. We're also looking at the verified risk assessment. But the verified risk assessment is not just something the Supreme Court has done. You all have adopted it and have made it part of legislation. So even if I wanted to change that verified risk assessment, I would not be able to do that unless I came back to you. Because it's no longer just an AOC rule or a Supreme Court rule. It's your rule that I have to look at the verified risk assessment, which we were trying to tell you yesterday. That verified risk assessment, I know we don't have a lot of time, but that thing has some major, major, major flaws.
Yeah, and that's not relevant to
I know, but it was only to his question.
I understand.
So that's why, but I'm not going to get into it. I apologize.
No, you're fine. Yeah, no
so-
apology necessary.
And the fast and speedy trial, you are right, Senator. There's 4 factors that we look at, whether a defendant's in custody or out of custody. We look at the length of the delay for trial. We look at, I'm drawing a blank. There are 4 factors: the length of the delay, the prejudice to the defendant, the reason for the delay. All those things you're saying are true. So that applies to a defendant who's in custody or out of custody, because the fast and speedy trial constitutionally, really how it all started. Yeah. So anyway, the long and the short of it is that in the defendant in jail is another factor. So but it's the liberty of a defendant is not the only factor about whether there was a fast and speedy trial. It's just a factor. Yeah.
You have another question, Senator? Senator Wheeler, last question. Only because no one else has asked,
Sure.
and I'm closing the door.
And thank you, Mr. Chairman. Just briefly, and because this was alluded to, and I want to be perfectly clear, my understanding was that if the defendant is the one that causes the delay of the trial, that doesn't really, the 180-day standard doesn't really attach. Am I incorrect on that?
Let's look at paragraph 10 on page 3. Basically, what happens is the only time the 180-day or the 90-day hearing would take place, the Section 10 hearing, would be if the defendant hasn't waived the right to a speedy trial, if the defendant has had blood or KSP isn't excluded, I should say, if competency is not an issue, if there's no good cause. So other than those factors, that's the only time that the hearing in 10 would be contemplated. Now, we did also put 10B in, which was the language that the victims' advocates requested, and that talks about if the court's already made that finding of public safety risk, then the defendant has the burden to come forward and show a material change in circumstances. That's in 10B already in the statute, or that we're putting in the statute, page 3.
So no actions by the defendant are going to be able to delay he's not going to be able to delay himself out of jail using this statute.
Exactly. And we've also put into this that these cases aren't going to be dismissed. We're one of 12 states that don't have an automatic speedy trial right. So what happens is other states that do have it, if the speedy trial clock is violated, the case is dismissed. We're not doing that. We're saying that the court then has a hearing to make a determination whether or not the defendant's to be released. The charges still stay standing.
And just real brief, Mr. Chairman, if I may be, a particularized risk to persons, those people can be in the community, correct? So in the event of a child pornographer, you could decide that this person represents a particularized risk to children in the community, could you not?
I believe so, yes.
Okay. Thank you, Mr. Chairman.
I think that'd actually be a slam dunk, in my opinion. I'm going to, seeing no further questions, do you have anything else you want to close with in 30 seconds, Senator?
No, thank you, Mr. Chairman.
All right. We've got a motion and a second on the sub, and it's before us. Is there a motion and a second on the bill as amended by the sub? Senator Turner, got a motion? Second from Senator Wheeler. Any further questions? Mr. Secretary, please call the roll.
Senator Berg.
And let me just say, I'm sorry, Senator, before you cast your vote, you each have permission to explain your vote. I'll give you a couple of minutes. 2 minutes, and I will watch the clock, and Austin will just keep on rolling with the roll. Go ahead.
I'm going to explain my I vote. I have heard from multiple prosecutors and judges in this state that they are adamantly opposed to this bill, and I can understand their concerns. And I understand your concerns, sir, and I do I go to intent, and I think the intent here is good. And I think you have shown a strong willingness to work with different groups to try to make this bill, which I think does have good intentions, feasible in a system that's clearly broken. And I would agree with everybody here, we need to fix this system. We really need to fix this system. It's a hard vote, but it's a yes. Thank you.
51 seconds. That's not bad. By the way, I'm not encouraging you to explain your vote. I'm just saying you can. Please proceed.
Senator Carroll. No. Senator Kerr.
I will yield my 2 minutes to Senator Berg if she has anything else she would say, and I vote aye.
Senator Neal. Senator Schickel.
No.
Senator Schroeder.
I'd like to explain my vote.
I apologize.
It's all right. Thank you, Mr. Chairman. You know, I was sitting here, I think, and somebody could correct me if I'm wrong, but I think except for Senator Stivers, I'm the senior person on this committee, on the Judiciary Committee. Who? Yeah, but he wasn't. Were you on before, Gerald? Yeah, committee members, yeah. On this committee. And it just seems to me like we don't learn from our mistakes. You know, I remember House Bill 463, and Keiko was here cheering on House Bill 463, and it was going to save us all this money in the jails, and even the Jailers Association. And, you know, I'm a former jailer, former law enforcement officer, and back then they were cheering that on. It's going to save us all this money. It was going to be great. We're going to rehab all these drug offenders. And all it's done is increased our jail costs and increased our crime rates. And since then, in my mind, we've had parade of soft on crime legislation, sadly. We've released prisoners from prison on the governor's orders, thousands of them. We've raised, and I'm ashamed to admit some of this I voted for. I drank the Kool-Aid too. Raised the felony threshold for theft. I just did that last year. I think looking back on it was a mistake. There's been a lot of them. What we're talking about here is basically, it's really pretty simple. Do you think our circuit judges are following the law and doing the law to their best of their ability? Or do we here in the legislature know better? You know, if we want to be circuit judges, we ought to run for circuit judge. Maybe we're in the wrong profession. But to sit here and second guess people who are sworn to uphold the Constitution and are elected by the people in their area and say, you know, we just don't have a whole lot of confidence in you, and we're going to interpret case law for you. And the judges I talked to, and also the prosecutors who did not testify, the prosecutors who are very much opposed to this law, the police who are very much opposed to this law, record crime rates here in Kentucky. What in the world are we doing passing a bill like this? Louisville, the most homicides in history. And our answer is this. Our answer is to start second-guessing our judges and telling them how to apply case law. For me, this is a sad day. I've been on this committee a long time, and I've been following the Vera Institute for a long time.
That's 3 minutes, Senator.
Okay.
Wrap it up, please.
Yeah, thank you, Mr. Chairman. I've been following the Vera Institute for a long time. Why are we listening to them instead of our police and our prosecutors? Thank you, Mr. Chairman, for your indulgence, and I'm sorry I went over the time.
Senator Schroeder. President Stivers.
Explain my vote, Mr. Chair.
Yes, sir.
I appreciate the discussions that have gone on here. I think they've been really good discussions, and I think I'm going to disagree with my good friend and colleague and former roommate. This is what we do. We're sworn to uphold the Constitution. We're sworn to establish policy. That is our jobs. And so in this, it's a balancing test. And I somewhat get offended by the people who say that I'm not conservative. You have fiscal conservative, you have social conservative, you have all types of conservative designations, but this is a balancing approach, and I don't see this as being soft on crime. I see this as concluding the case, getting the case over with in the most efficient and timely manner. To me, resolving a case is the ultimate solution to all things, because justice delayed is justice denied. And this pushes people to get the case resolved. Thank you.
Did you cast a vote? Thank you. Yes, Senator. Go ahead.
I just want to say that I appreciate what the President of the Senate just said, because that's what this is really about. We can point to individual things and try to connect them in some sort of way at this particular forum, but it's impossible to do. This is a matter of how we undertake and actualize the Constitution, and it's out of whack. So maybe this will force us to do some other changes within the system to accommodate those things that someone may find deficient by what I consider a common sense move. Thank you, Mr. Chairman.
Thank you, Senator. Go ahead, Austin.
Senator Turner.
Mr. Chairman, I'd like to explain my vote.
Yes, sir.
And I do vote aye. I appreciate this being brought. The people need to know this thing's going out of committee, so it gets a full oversight by the full Senate after this, and I appreciate that. Maybe the people sitting here don't know that the bond said, I understand, for that fellow did the shooting in Louisville was $100,000 cash. And you know what came across my phone a while ago? Somebody posted bond for him. Proof in the pudding in my 42 years of practicing law that the people that suffer for this, and it's only the, remember we're talking about innocent people, are those people who can't afford to post bond that's being held. And you can talk about all you want to, findings and everything, because that person that shot at that fellow yesterday or the day before, whenever it was, is out on your streets now. Because some judge made, I think, probably used all the techniques they have to say that he's got $100,000. Somebody posted it according, I don't know whether that's true or not, but I think it came across mine. If anybody else in here got something different. So that's proof in the pudding. It's the poor people, and I'm glad we're getting it out for all this discussion. Thank you, Mr. Chairman.
Senator West.
I'd like to explain my vote. Yes, sir. I vote aye and reserve the right to change my vote on the floor as the process keeps moving along. There's several reasons we're here. Lack of judicial redistricting, COVID, labs, competency hearings, whatever. Those are definitely not the fault of local courts, but they're also not the fault of the defendant. And the defendant has a right to speedy trial. Everybody up here swore to uphold the Constitution. That's part of the Constitution. And the real problem I had, the reason I vote aye, is the bill sponsor has 180 days in here. And I can't get anybody on the other side to give me a time frame. You know, how long is too long for somebody to be held? And so hopefully if some people from the other side would come together on this, then we could get something accomplished. But thank you for bringing this bill.
Senator Wheeler.
Mr. Chairman, explain my aye vote.
Yes, sir.
You know, look, trust me, I have consistently supported the police and law enforcement down here. I've consistently supported our judicial officers, our judges. But, you know, as Senator Turner and Senator Stivers both mentioned, I mean, there is a value to the community in moving these cases along. And I think that's all this bill encourages folks to do. It still preserves that judicial discretion, as the drafter noted, to hold those people that represent a real and present danger to the community. If that was not in there, I could not be. I would be a no vote on this bill. I don't want criminals roaming the streets, but you know, at the same time, we do have to look at the fact that it is a founding principle of our republic, unlike many other countries in this world, that you are innocent until proven guilty. So, you know, this is I think this bill strikes the right balance between preserving individual rights and protecting our community. So I will cast an aye vote.
Chairman Westerfield.
I vote aye. I'm going to use my vote explanation to respond to a couple of things. I have all the respect in the world for law enforcement, for the gentleman from the FOP, with whom I stand on just about every issue they bring before this committee that's come up before. Bills have been stopped cold because their feedback means that much to the chair and to this committee. But I disagree with them on a couple of things that they mentioned. I can't speak for the rest of the country, but there's been no bail reform experiment here. We haven't been able to get anything passed. I don't believe this bill is about bail reform. I'd love to get rid of money bail entirely because I think that for the very reasons Senator Turner just mentioned, I think there are constitutional issues because if you've got means, bail is meaningless. You can set it wherever you want. And then there's a whole conversation about what happened in Louisville yesterday where we've got private organizations coming in and footing the bill for people. I think that might end up driving bail values up for everybody. And those organizations don't have skin in the game. That's a whole other conversation this committee may end up having. I know House Bill 313 is out there, sponsored by Representative Blanton, that addresses that. But we haven't been able to reform bail here. And again, I don't think this is a bail reform bill as much as it is a speedy trial bill. I'm not even concerned, and I appreciate Judge White's testimony. The cost concerns are really not important to me. I know it's important to the judges and to the county jailers and counties generally. My concern is about the constitutional rights of the people that are in custody and who are, as Senator Wheeler just reminded us, and as the sponsor, Senator Storm, reminded us at the beginning of the meeting, they're innocent still. And if it did require, much like Senator Wheeler just said, if it required that these folks be let out and that judicial discretion was thrown out the window, I wouldn't be hearing the bill. But I asked you questions, Senator Storm, and you responded in the affirmative each time. Can the judges keep these people in? Yeah. And so with respect to the examples that Judge Ward shared, I find it really hard to believe a judge can't find cause and make a finding on the record, on their calendar order, why they're keeping someone in custody in every single one of those fact patterns. We aren't releasing anyone, and we are giving judges the power to keep those very people in. And I think it's not too much to ask for them to make a finding on the record of that. We are putting in that clear and convincing evidence standard, but I think that's appropriate. A couple of people have made reference to murderers and homicide cases. Capital cases don't apply here. We've covered that ground already. And Judge Ward is absolutely right that we need to give more funding to the lab, to KCPC. I had a conversation with DPA this morning, and they have the lowest paid lawyers in all of state government. I've seen a chart. They are woefully underpaid compared to every other lawyer, including non-elected prosecutors and including lawyers in every other cabinet of state government. And their folks are the lowest paid. And the governor did them a favor and gave them not a penny in his proposed budget, which was a sucker punch to their morale. All of these folks need more money, and the lab certainly does, so that folks aren't having to wait, which is a frustration for crime victims. It's a frustration for the defendants and for their counsel, and it's certainly a frustration for the court who wants to get these cases through. That's why this is carved out. I'd love to throw in more money, but I only get one vote out of 138, and I can't do it by myself. And I'm fighting that fight, and so are others. But in the meantime, this, as Senate President Stiver said, accelerates the outcome. Try them. Lock them up. I'm pretty sure I cast my aye vote. I think the total is 8-3. Bill passes with favorable expression. Thank you, Senator. Thank you, everyone, for your presentation and your comments. I appreciate it, and it is with great respect that I entertain all of those and that we hear those in this committee. They're valuable to us, and I appreciate the time that all those groups, including Judge Ward, Judge Summey, and a slew of others, have spent with Senator Storm, and that Senator Storm has spent with them, with just about every prosecutor in the state. I know members have gotten a ton of emails, so we've gotten a lot of feedback, and I appreciate the time that everyone's given to it. Thank you.
Thanks, Mr. Chairman.
The next bill is Senate Bill 63. We're not going to spend 53 minutes on this one, mainly because it's a bill we've seen before. Now, there is a committee substitute, and I'm going to entertain a motion and a second on that right now. Got a motion from Senator Schickel. I'll make the second. Okay, Senator Wheeler will make the second. All those in favor of adopting the substitute, please vote by saying aye. Aye. All right. Senator Carroll, you've got the floor. You make your prepared remarks. We've got folks from the Press Association that want to speak, and I want to give them time to speak. But as this is something, in fact, not only has this committee heard before, the legislature has passed before. It was vetoed last year, so this is old hat. Senator, go ahead.
Thank you, Mr. Chairman. I'm Danny Carroll, the state senator from the 2nd District. Go ahead.
I'm Sean Butler, the executive director for the Kentucky Police Chiefs Association.
Is your green light on there?
I'm Sean Butler.
There
I'm
we
the
go.
executive director for the Kentucky Police Chiefs Association.
You have the floor, Senator.
Thank you, Mr. Chairman. Mr. Chairman, this bill, Senate Bill 63, is a bill designed to protect the personally identifiable information of members of the criminal justice system. And I think what I'm going to do, since I think members are familiar with this bill, I'm going to go through just some of the changes that are in this bill, and then we can get into detail in the other aspects as well. Basically, the bill defines public agencies that this information is related to. It defines who is protected. In this bill, it has to do with the public officer that's protected and immediate family members. I have narrowed down the definition of immediate family member. The bill from last year, Senate Bill 48, the version that we passed, was it somewhat expanded where it included family not living in the residence. So this bill protects a spouse, child, parent, or person under familial custody or care of the public officer, or a person who is living in the same residence as the public officer. And those are the ones who are protected from the disclosure of the personally identifiable information. I'm going to refer to that to PII from this point forward. And I would ask that you all have the draft in front of you, and if you have questions, just follow along. In Section 1, it makes the definitions, all those that are included as a judicial officer, defines what PII is and what information is protected. And it's personal information, date of birth, account information from a child, relative in the home that is protected. And there is a pretty long list there of things, information that is protected. School, daycare, or employment location, Social Security number, vehicle registration, and you all can follow on down that list. And I would also advise that this does protect those who are currently employed and those who are retired. In Section 2, it adds PII to the list of a public officer in the immediate family to the list of public records protected from open records, unless, and this is existing language in the statute, and I think this is important to this, unless upon order from a court of competent jurisdiction. And what that means is basically if someone is denied access based on this law, should this pass, then they do have remedy through the court system to gain access to the information. And I would also advise that current language.
We got a motion from Senator Schickel and a second from Senator Wheeler. I don't want to cut you off, but
Mr. Chairman, I'm happy to stop.
All right, I'm gonna let the folks from the Press Association come up. Also want to draw members' attention to a letter that should be in members' folders from the Kentucky Open Government Coalition, or I think that's the name of the organization, Ms. Benson Haver's group. Even if it's not in your folders, and it should be, but even if it's not, or for people in the audience or listening online, it's on the web. Thank you, that's it. It's also on the website under the meeting materials link, or it should be. They could not be available to speak. I'm going to have them come up, Senator, and I'm going to give you the last word after that, if that's okay. Yeah. We got Rick Adams, Robert Thomas, and Andrea Stallman. You all can come on up. Y'all might need to scoot or move for a moment. You're all nested, and I kick you back out.
Thank you.
Good morning. Or just for another couple minutes. Good morning. You have the floor. Go ahead.
My name is Rick Adams. Thank you, Mr. Chairman, for having me today. I'm legal counsel for the Kentucky Press Association, and I'm here to testify on their behalf today against Senate Bill 63.
I'm Robert Thomas. I'm news director at WKYT in Lexington.
I'm Andrea Stallman. I'm the news director at WLKY in Louisville. We are here on behalf of the Kentucky Broadcasters Association.
I knew that. I apologize. If you all don't mind, make sure your mics, your green light's on. And then go ahead.
I'll start. Mr. Chairman, the members of the committee, Kentucky's Open Records Act has made our Commonwealth a national model for government transparency while balancing the need to protect private individuals' information. SB 63 will bring that status to an end. It is an unconstitutional bill that will censor the publication of information. It, for the first time, imposes civil liability for the publication of truthful information about public officials. That will unconstitutionally chill all manner of protected speech. It is frankly an attack on the First Amendment and Kentuckians' due process rights. The bill's incredibly broad application creates far more problems than it solves. It leaves public agencies, journalists, businesses, and citizens unsure of what they can say or do concerning a wide range of Kentucky's most powerful public officials. The bill's unintended consequences are impossible to overstate. The bill can be separated into two key components. First, I want to talk about Section 5 of the bill, which imposes the civil liability that I've mentioned. This is a dramatic departure from existing law. As I said, it imposes civil liability for the publication of truthful information about a public official. The bill allows compensatory damages, punitive damages, court costs, attorney's fees against any party for publishing or sharing relatively benign personal information, even if that information is already public. And what's worse is it imposes this financial liability based on just the subjective assertion of the public official whose information was published that they were somehow harmed or threatened by that publication. These substantial penalties will stifle or punish all manner of constitutionally protected speech. The bill is so broad as to impose liability for publishing the name and employment assignment of any public official protected in this bill. Any number of essential stories published by KPA members across this Commonwealth would have been impossible to report and publish under this law. I'm talking about groundbreaking stories that expose habitual perjury that resulted in the release of wrongfully convicted Kentuckians. I'm talking about stories about the sexual abuse of minors that would otherwise not have been made public. And it's not only these major stories that will be affected, it will make it impossible for local media outlets to report on bread and butter local stories that have stories like crimes in the community, court proceedings, or even positive contributions of these public officials that are protected under the bill. Citizens and journalists will just simply not know whether they can talk about or report on public officials, employees, or controversies that happen to turn on the categories of information that are protected by this law. That is a clear violation of the First Amendment and the Due Process Clause. That's all Section 5. That's bad. Section 2 and 3 aren't much better. Together, these sections do two things. First, Section 3 mandates that upon the request of a protected public officer from this bill or their immediate family member, an agency must redact and remove previously published personally identifiable information within 72 hours. Section 2 then adds a new exemption to the Open Records Act that requires agencies to withhold this information in records if it would reveal the address or location of a public officer if they have requested that information redacted under Section 3. That is so open-ended that it can cover some basic information such as names and employers. After all, if I publish someone's name, first and last name, their address can be discovered in the white pages, and their job title and employer can be used to identify their work location. These provisions are unworkable. It brings essential functions of government to a halt. Just think of how will title companies and mortgage lenders perform routine tasks essential to the public functioning of commerce without public information on deeds and liens. I think another important example is KREF. Under this bill, KREF will be required to delete personal information from public view if requested to do so by a public officer. Many judges, prosecutors, law enforcement officers in Kentucky are elected officials. Access to their political donations is essential for Kentuckians to monitor corruption issues. To illustrate this point, Governor Beshear is a former attorney general under this and is therefore a public official that's protected under this bill. If he so chose, he could write a letter to all government to KREF and ask that they conceal and redact all of his political donation history in perpetuity. And for all of its problems, this bill provides not much benefit. The Open Records Act already protects personally private information. And if the legislature believes that definitions should be broadened, it's easy to add an exemption to the Open Records Act that would exempt narrow categories of information from publication.
I'm gonna ask you, because we're trying to get through several things, if you could circle for a landing. I know you've got remarks, but I want to try to wrap it up.
Yes, Mr. Chairman. I would just conclude by saying that this bill, it's been said that it's based on Daniels Law in New Jersey, which was passed about a year ago. Within 1 year of that bill's passage, the New Jersey legislature has had to pass a new bill cleaning that bill up because it was unworkable, not just for press associations, but for their county clerks, et cetera. It required a $3 million appropriation to create a new government agency called the Office of Information Privacy that essentially acts as a clearinghouse for these requests to redact information, and that the general inspector of that office has broad investigatory powers to investigate any of the requests made and accept or deny them because the bill was unworkable to start. So I urge the committee, this is a bad bill for Kentucky, I urge the committee to vote it down today, and I'll yield to the rest of the people up here.
Okay. I respect the intention of Senate Bill 63 and the attempt to prevent offenders from knowing where public officers and their immediate families live and work. Journalists and other professionals in our state have the same concerns. But I believe Senate Bill 63 will have unintended consequences if passed in its current form. Our country was built on the principle of a free press. It's part of the First Amendment. Now, would journalists be forced to defend in court the publishing or broadcasting of truthful information? A public officer could sue for civil damages and punitive damages anyone who disseminates personally identifiable information about them or an immediate family member. Under this bill, some of our highest elected officials would qualify because of their prior experience. And that includes members of the legislature, the attorney general, and the current governor, as we pointed out. The goal in our reporting isn't to give someone a roadmap to find a public official's home or put their loved ones at risk. It's to create change, expose wrongdoing, and ensure those without a voice are heard. I think this bill would have a chilling effect for investigative journalism in our state and would create challenges for journalists and records custodians, lead to potentially costly legal battles, and give potentially bad players the ability to hide from the public's watchful eye. Watchdog journalism relies on open records access.
Thank you, Mr. Chairman, and other members for allowing us to speak today. I'm going to start by saying I was born and raised here. I am thankful each day to live and work in my home state. I'm a proud Kentuckian, and I'm dedicated to the service of local broadcast journalism. I believe that the dedicated work of local journalists is a necessary function in not only our democracy, but it's critical to the health and safety and the growth of our state. First, I must express that I understand what is at the heart of this bill, the protection of life, and specifically those serving in a law enforcement capacity who may become targets, or their families who may also become targets. My father is a former FBI agent who worked for 30 years in Louisville. He proudly served Kentucky and our entire country throughout his career, working many high-profile and often dangerous cases. I was that kid at home while her dad was out working a bank robbery or a murder investigation or other cases that I wasn't allowed to know about. I sincerely understand the intent of this bill, but I am asking today that you continue to work on it to make sure that Kentucky's open records law is not so drastically changed that it would impede the critical abilities of local journalists. It is the blanket application of the bill that concerns me. As a career journalist, I cannot recall a time that we have published someone's personal address or their phone number. In fact, our newsroom, like most, has legal and ethical policies in place so that we can responsibly report on issues of public importance while at the same time protecting personal information that could put subjects of news stories at risk of threat or violence. This law, as is, would simply remove a whole swath of public information from public scrutiny. I do not believe blanket exemptions should be granted based solely on a job title or someone's relationship to that person. At the very least, a strict approval process to determine a critical need for an exemption. Also, as mentioned, there is no cohesive central system for intake or monitoring of these exemptions. In New Jersey, like he said, they realized after implementing the law, and if we have that as a model, why is this not part of our discussion or our plan? Why is there such a rush to do this? Exemptions will certainly create an administrative backlog, and that will halt open records requests. They will not be responded to or filled in a timely fashion, and already it takes a while. Information that was currently being used to check the public trust will no longer be available to us as it was. I am concerned about the burden this will place on county agencies to keep track of information and also the consistency of the systems that each will use to track the exemptions. Lastly, I would like to address the issue of liability in this bill. The proposed civil liability provision is a major concern for journalists. It would put any person who disseminates the subject information at risk of a lawsuit, regardless of how or from whom they obtained this information. The financial burdens caused by this would create a significant chilling effect on our coverage of matters of public interest. We do not see the logic in making anyone liable for the release of protected information in public records other than the public agency that actually releases that information. In our view, any liability related to the release of public records must be limited to the public agency that controls those records. At an absolute minimum, I am requesting that journalists specifically be exempted from such liability. In closing, I would like to reiterate, I am familiar with the heartbreaking genesis of Daniel's Law in New Jersey. As a journalist and a citizen of this state afforded the services of law enforcement and others referenced in this bill, I certainly understand a reasonable protection of private information. But I do not believe it should be accomplished by such a blanket elimination of public access to information. I fear this bill would devastate the good that true investigative journalism can do and does do in our communities. And the liability risk, simply put, would unconstitutionally have a chilling effect on journalists tasked with carrying out our First Amendment protected freedoms. I would request more work be done on this bill to consider how Kentucky would manage the exemption process, remove liability for journalists, and protect the rights of the public under the First Amendment. Thank you for your time.
Thank you all so much. Senator Schroeder's got a question of this panel or of Senator Carroll?
Thank you, Mr. Chair. This panel, I'll be honest, I'm struggling. I don't understand. I wrote down create change, expose wrongdoing, make sure changes are made. And where I struggle with your guys' argument, I don't understand to accomplish any of that for any of the individuals on this panel or any elected officials. You can do that without publication of an address, without publication of the children's names. I mean, fill me in. We're always doing a balancing act, right? Yeah. And in this case, we're balancing safety. And to me, it doesn't really seem that hard. You still have access to our address here, to our title. And as far as the KREF example, I don't think the way I understand the bill, no, he can't say remove all my political donations. What he can say is remove the address associated with those political donations.
So I would certainly like to answer that question. I think the personally identifiable information is so broadly defined in this bill. For example, it includes employment location. So if a reporter were to go to the local courthouse to just report on what was happening that day, and they mentioned a judge's name and the courtroom that they work in, that's a violation under this bill. It's so broadly defined that basically any information that could lead someone to discern somebody's location at a given time could subject them to civil liability, not to mention the preemptive redaction of public records that could be requested by any public official under this bill.
And I wanted to add, like, while people's names would remain public, we, as journalists, we also rely on other identifying factors in our reporting. I'll use myself for example, Robert Thomas. There are 326 Robert Thomases in the state of Kentucky. There are 8 of them the same age as me, and 3 of us live in Fayette County. So if we were doing a story about me, like, we would want to cross-reference and be able to make sure we're identifying the correct person. There are also 59, the senator who proposed this bill is Senator Daniel Carroll. There are 59 Daniel Carrolls in Kentucky. So, I mean, I think for us to have not necessarily we want to report some of that private information, we use it to cross-reference and making sure that our reporting is accurate.
Mr. Chair, quick response. I mean, I'm not aware of anyone in the General Assembly having the same name as another General Assembly member. We're talking about elected officials. We're not talking about the 4.4 million Kentuckians. We're talking about elected officials. You're still allowed to use their title. You're still allowed to use their name. Thank you.
Can I just
we've got to move on. Seeing no further questions, we've got a motion and a second. Do you want to close with 1 minute or less, Senator, please?
Mr. Chairman, I'd like a little more time than that. I think this bill has been badly misrepresented.
I agree that it's been badly misrepresented.
I'll do it quickly, Mr. Chairman.
Thank you. Well, unless I'm much mistaken, it's about to pass.
Yeah, but Mr. Chairman, I think it's important for the public to know some of the things that our guests were harping on that invokes the civil liability part of this. And there has to be some malintent in the release of the information. It has to be in response to a decision or action or to influence or impact any future action taken by the public officer as part of his or her official duties, and with the intent to intimidate, harass, threaten, or alarm. And the dissemination places the public officer or his or her immediate family in reasonable fear of physical injury or reasonable fear of harm to their property. So it's not quite as simple as our media folks reported. This does not hide any actions of anyone. It's just the PII. And as far as business transactions, those are addressed in the bill, and those transactions are allowed through the legislation. And there is an argument that it is already protected. So if it's already protected, how can it be unconstitutional? And in this day and time, any public agency that is doing the right thing would be protecting this information. And all we're saying is it will be protected, and the process is the same. If you want remedy, if you want access to it, you go to the courts and you file remedy in the court of competent jurisdiction, and the information can be obtained. You only have to look at what's going on in the world, especially the last 2 years, to understand the need for this bill to protect those who protect us. Thank you, Mr. Chairman.
Senator Wheeler, last question.
Just briefly, Senator Carroll, just for example, just hypothetically, let's just say I was a multimillionaire, but I got on the floor of the Senate. I'm just a working class American. I live in a small house. I don't have a beach house or anything like that, but I owned a 15,000 square foot mansion on the inlet in downtown Miami. Would they get in trouble if they posted like an aerial shot to show my hypocrisy of my house down in Florida?
As a state legislator, you're not protected.
Let's just say you were an officer and you testified to that in an action or something like that.
If it's one of those that protected, again, for there to be any civil liability, that intent in those three categories that I just spoke of, that would have to be established for there to be civil liability involved. There has to be some intent to harm someone in the release of that information for the civil liability to kick in.
All right, we've got a motion and a second on the bill as amended by the sub. Mr. Secretary, please call the roll.
Senator Berg.
I think this bill is much, much, much better than the one I saw last year. I still have concerns, and I will currently vote no. Thank you.
Senator Carroll. Aye. Senator Kerr. Senator Neal.
I'm going to vote no at this time, but I'm going to reserve the right to change that position. I want to look deeper into this because of the issues that have been raised here and because of its implications with respect to the First Amendment. Thank you.
Senator Schickel, Senator Schroeder, President Stivers, Senator Turner, Senator West, Senator Wheeler,
Aye.
Chairman Westerfield.
Aye. I believe that's 9-2. Bill passes with favorable expression. Thank you, Senator.
Thank you, Mr. Chairman.
Making an adjustment here, we're going to use the last 12 minutes to cover Senate Bill 153. We're going to skip my bill 114 and take that up at another time. And unfortunately, we're going to skip Senate Bill 110, but that'll be the first bill that I call at the next meeting. Senator Thomas, I appreciate you bringing the bill, and I apologize for not having adequate time with education meeting at 11:30. I lose everybody in 12 minutes. And your bill is going to take longer than 12 minutes, and I want to give it more than 12 minutes, frankly. So, Senator McGarvey, come on up. We got 12 minutes.
Thank you, John.
Thank you, Mr. Chairman. I believe there's some people here to testify. Mr. Pfeiffer, Cal?
You all come on up. If you're here with Senator McGarvey or in support of Senate Bill 153, that's your cue.
Well, we have everybody getting seated, Mr. Chairman. I appreciate the time. Appreciate you all fitting us in today. I want to introduce who I've got with me here. Cal Pfeiffer. He is a constituent. He is a victim of childhood sexual abuse, and he has become somewhat of an expert on these topics. Catherine Robb is here virtually. And I believe Dr. Eric Russ is here virtually as well. Let's get to the substance of the bill. All this bill does is remove the civil statute of limitations for victims of childhood sexual abuse. Why is this important? This is one that came to me from a constituent. In fact, 1 in 10 people under the age of 18 are likely to be victims of childhood sexual abuse. Nearly 1 in 4 girls, nearly 1 in 13 boys will be some type of victim of abuse. The reality is we're getting to understand this. The average age of coming to grips with this is 52 years old. Think about this. When a child is abused sexually, it is often by a family member, by a loved one, by a friend and neighbor, a trusted person in the community, whether that's church, Boy Scouts, school. To take the courage to come forward takes years. And because it takes so many years to come forward, the current statute of limitations for civil actions, again, this is civil actions, not criminal actions. Civil actions is only 10 years. If you're abused at age 8, age 9, your statute of limitations runs when you're barely an adult. And so we're seeking to get rid of that statute of limitations for civil actions to make victims whole and get them the relief they need. With Mr. Pfeiffer here, I'd like you to introduce yourself and go ahead and testify for the committee.
Thank you. My name is Cornelius Pfeiffer, go by Cal. I'm a member of the Child Sexual Abuse and Exploitation Prevention Board under the auspices of the governor. I've been involved with supporting victims of child sexual abuse for the last 20 years. I see now as an opportunity to simply put change the statute of limitations, which silences victims and protects predators. Because of the limited amount of time, I was going to read some documentation that child sexual abuse has been known for many years. This is my abnormal psychology book from college, copyrighted in 1964. That's 58 years. Leads to the question, why hasn't this been brought up before? Kentucky leads the nation in child sexual abuse. A question that also in eliminating the child sexual abuse, it provides a means for a victim and a survivor to be believed, to have their day in court. Provides validation, potential reimbursement for maybe years of therapy expenses. Provides vindication, and it outs perpetrators. Ultimately, it helps in healing the wounds that have been created for these people, the victims and survivors, that they've been injured for the last 20, 30, 40 years. And addressing this issue, I believe it needs to be addressed now while the opportunity is here, not pass it off to next year or maybe another year. Many other states have addressed this, discussed it, and have led the way. I think.
Sorry to interrupt. Do you know how many states have a statute in place still? Do we know that off the top of your head?
I believe there's about a dozen.
Yeah, it's not. A lot of states have a statute that is longer than Kentucky's,
Okay.
significantly longer. There are still even a good number of states that have no statute of limitations whatsoever.
Okay. Got a motion on the bill from Senator Neal, second from Senator Kerr. I don't want to cut you off, and I want to let these other two folks speak. If you think Senator, if you want them to be heard, I don't want to cut anybody off. And I don't think there's anybody here to oppose the bill.
Then my grandfather always said, "Don't sell past the close."
That's right. Anybody have any questions of the senator? All right. With apologies to our guests who have appeared remotely, you're all good. So just hang tight. I've got a motion and a second on the bill. Mr. Secretary, please call the roll.
Senator Berg. Senator Carroll. Senator Kerr. Senator Neal. Senator Schickel. Senator Schroeder.
Mr. Chair, explain my aye
Yes,
vote.
sir. Yes, sir.
Thank you. I do vote aye. I just want to say we have been working on this.
Yes, sir.
In 2017, we extended statute of limitations for minors to 10 years. At the time, we felt 10 years was the best we could get, and we're making progress. We're making progress again today. I vote aye, but we haven't forgotten about this. We're working on it.
President Stovers. Senator Turner. Senator West.
Aye.
Senator Wheeler. Aye. Chairman Westerfield.
Aye. Bill passes 8-0. Bill passes with favorable expression. Thank you, sir. Thank you, Senator McGarvey. I appreciate it. Guests online, thank you both for your willingness and your patience sitting through the meeting only to not talk. Want to thank Senator Schroeder for pointing that out. I remember the bill, remember Senator Schroeder's work on that, and I appreciate it. Senator Thomas, Senate Bill 110 will be first at our next meeting, which will probably be next Thursday. But members, again, that's another one, by the way, as a reminder that we've seen before. Senator Turner's brought this bill before. We've passed the bill before, if I'm not mistaken. So take a look at that. A short, simple bill, right, Senator?
Yes, it is. Yes, it is.
All right.
But I got you.
Seeing no further business coming before the committee, we stand adjourned.
Great, great. Yeah, that's important.
Thank you so much. Thanks for coming up here in such short notice. Thank you. Thank you. Yep. I gotta get the committee to say.
Oh, that was fun, you all.
Thank you so much. I've got to run to 11:30 myself. I am. I don't know which Morgan. You're kidding. Oh. That's the grandfather I referenced while we were sitting there. We were so close, he was a groomsman in my wedding. Thank you. He is, yeah. He graduated 10 years ago. We talked almost every day. CJ, of course it was CJ. They love CJ. Yeah, loved it. That was your son.
I finally put you two together. Sorry, John.
No. That's no, Morgan's my mother's maiden name, and my grandfather always said, if anybody names a child Elmer, I'll change my name. Because I wanted to name my son Elmer.
Sounds like,
yeah. So that's what he was. Elmer Lucy.
Oh, that Dave Pottinger and Pat.
Yeah. And Pat's still living. Tommy passed away last August. He was battling Parkinson's. It was bad, but it was Tommy.
Sometimes it's
So, thank you for coming. You know, this makes. I'm going to call my mom. The next time I get a break.